Thank you everyone for joining us. Again, if you haven't yet updated your Zoom name to your first and last name, that would help us get everyone checked into this webinar. And I want to welcome and thank you for attending our webinar today. My name is Jacob Marty. I'm a financial advisor with Wealth Distribution Strategies. And at WDS, our mission is to help our clients achieve their financial, family, health, charitable, and social aspirations one conversation at a time. So this evening, we will have two speakers who will present to you for about the next 45 minutes, and we'll conduct a short question and answer at the end of the webinar. This webinar will be recorded and made available to you in the next few weeks or so. So if you have any questions during the webinar, please type them into the chat window and we'll address them during the question and answer at the end of the webinar. So tonight's conversation will cover some ins and outs of estate planning as it relates to setting up wills and trusts specific to your needs. I'm excited to introduce to you to tonight's speakers, both attorneys at Boardman and Clark here in Madison, Wisconsin. Tom and Rob come to us with years of experience with estate planning. Tom practices in the areas of estate planning, probate, and trust administration. His experience in administration helps him recognize where estate plans can go wrong and how to prevent the aftermath of a poorly constructed plan. Rob's practice focuses on helping clients with trust and estate work as well as general business matters. So without further ado, I'll hand the floor to Tom and Rob. All right. See if Rob can join. All right, there we go.
All right, good evening, everyone. It's nice to be with you. So tonight, Tom and I are going to speak with you about wills versus trusts. And I'm going to take a step back and start with thinking about estate planning a little more basically. So first, we're going to just start with talking about what is estate planning and what makes up a full estate plan. We're going to talk about what happens if you fail to plan and why it's just important, regardless of what avenue you go down. We think about each of those actions purposefully. Then I'm going to go over what a will is, and then Tom is going to discuss trusts with all of you. So what is estate planning? Estate planning is, as it says, arranging for the management and disposal of your estate during your life and at your death and incapacity. And really what this boils down to, and what I think oftentimes gets undersold, is we're here talking about wills and trusts. So I think from a starting point, we're thinking about what happens after we pass away. But a lot of the planning and the important decisions affect what happens to us and how do we get taken care of during our life. And so, who's making our financial decisions for us if we can't make them? Who's making our healthcare decisions for us if we can't make them? And how do we avoid, if we have a well-managed plan for both managing our assets at life and at death, how do those things work together to make sure that we don't have any faux pas on either side of that line? So a will is just one part of your estate plan. And the goal of your estate plan, is you've spent your life working or doing something to accumulate assets, and you have priorities, whether they be family, charitable, or something else. And so, it's about forwarding your assets to take care of yourself and then to further your larger goals. And often, as part of your estate planning, we think, okay, we did our will, we have a trust, it's a one and done, we can move on. And one of the things that we're going to talk about is there's things that we're doing every day that affect our estate planning, whether we realize it or not, and either are going to be complementary to it, or they're going to undo it in some pretty big ways. So other documents that are part of your plan. So your powers of attorney for healthcare or finance. And these can be as basic or as complicated as you want, right? I have parents all the time who have kids that they want making certain decisions for their finances, but not other decisions. And so it's not a one and done. We need to figure out what works best for you and your family. Marital property agreements, right? We live in Wisconsin. It's a marital, if you're married, your spouse automatically owns one half of everything you own, whether you realize it or not. And there's times in our estate plan that we want to purposefully hug the marital property laws. And there's also times, though, for example, if there's a second marriage or significant family assets that it's important to keep in individual to one spouse, where we want to have a marital property agreement so that your estate plan can function the way you intend it to, and that marital property laws don't get in the way of that. Your beneficiary designations, whether on your life insurance policy, on your brokerage account or your IRA, all over on your house, there are all sorts of places that you can put beneficiary designations. But if that beneficiary designation isn't complementary to the rest of your estate plan, you've done yourself a disservice. So what I don't think a lot of people sometimes realize is if in my will, right, I give everything to my two kids, but I make the beneficiary of my life insurance just one of those kids, that asset is going to pass to the one kid. And there's not much the other one can really do about that. I can't tell you it's one of those things that you're doing something thinking you're forwarding a goal because your will says one thing, but you're taking another action that's going contrary to your intention. For those of you out there who have businesses, right, shareholder buy-sell agreements, operating agreements, especially where you're just one share, if you have multiple parties, and a well-drafted one, shareholder agreement, operating agreement should complement your estate plan. Who do you want your stock or your membership interest to go to? Where do those proceeds go? And if it's your intention to pass a business asset to one of your children, but your corporate documents either don't allow that or put multiple roadblocks in the way, your estate plan isn't going to function the way you want it to, because there's going to be other parties who get to dictate what happens to that asset. And then asset ownership structures. Similar to what I said with the beneficiary designations, a lot of times folks will come in and they'll say, right, I put my daughter on my checking account so that she could help me out. Okay, well, how did you do that? Did you put her on there as an agent or as a joint owner? And sometimes without realizing it, right, we go into the bank and we do what we think we're supposed to be doing. If we make Rob the joint owner on your bank account, when you pass away, that bank account becomes Rob's. And so again, your well-laid plan of it's supposed to go to a trust or to all your kids equally rely on Rob just doing the right thing with that, but not really having a legal obligation to do that. And so those are all things that we do every day, whether or not we realize it, that can make or break whatever we draft for you on paper. So the big question is, sometimes people go, well, what's it matter? If I don't do anything, who's it really affect? And so generally speaking, with the laws of intestacy, right, if you're married and you have either no children or all your children are children of that marriage, everything goes to your spouse. Otherwise, if it's a second marriage or there's children from a prior relationship, your assets get split amongst those people. If you're a single person and you don't have a spouse, but you have children, it'll go to those children. If you don't have a spouse or a domestic partner or children, right, we're going to start going up your family tree and finding folks. So sometimes people will come to me and they'll go, well, I want to make sure that I'm getting a will so that when I pass away, the state doesn't take it all. And that's generally what people think happens is, right, if I pass away and I don't tell it where to go, that some third party can just come in and take it. And what really we need to discuss is we're going to go skimming up and down the branches of the family tree. And only in that instance where we can't find a living person on the family tree would it ever go potentially to a governmental entity. Now, as we're skimming that family tree, there could be a whole lot of people that you don't want touching your estate. Long lost cousins, brothers, sisters, nieces, nephews that you would never dream of giving it to. So the purpose of your will is to push your assets into a direction and hopefully away from those folks or those things that we don't want to interact with it. And then one of the other things is if you're going through, if you die intestate, you're probably going to have a probate proceeding. And there's nothing wrong with that. It's only bad if you don't want to be there. So if you fail to have powers of attorney, what happens? Well, there's nobody authorized to make your decision. That doesn't mean that there aren't instances in life where you get a well-natured person who at the post office or at the hospital who helps you out, right? Those are typically challenging times. Emotions are high. That's a perfectly reasonable thing to happen sometimes. But in the grand scheme, there's nobody authorized to make decisions when you're not able. And so what ends up happening is if Rob's incapacitated and can't make a decision, a court process needs to be initiated, whether that be for my healthcare decisions, my financial decisions, or both, of appointing somebody to make those decisions on my behalf because Rob is no longer able to. And the big thing is if I don't have a power of attorney, I get to handpick my agent, right? I can say, I trust this person and they know what I think, they know what I want, and they'll do that. If we rely on a guardianship to come back and to cover the and to take care of providing that decision maker for you, it may not be somebody who knows you, and it may not be somebody who you'd want to make those decisions. So you're giving up your right to control the decision maker and your stated intentions in those situations. So what is a will? A will is just a written document that you make that disposes of the assets that fall into your probate estate. And they're specific to each person, right? So you and your spouse may have wills that mirror one another, but you're still going to have one to each of you. They're unique to you. But I often tell people spouses can have different wills, right? There's certain, when I was talking about marital property agreements, there are laws out there that will prohibit you from writing your spouse out of their portion of the marital estate. But generally speaking, you are free to dispose of everything that you want. So there's no right or wrong when it comes to spouses and how to potentially give to different grandkids or charities and whatnot. After your death, it not only serves numerous functions. One, it appoints your personal representative, your executor, and that's the person who, right, is going to go to court and then say, hey, court, on these documents, Rob passed away. Here's some information about Rob. If nobody objects, the court will admit the will. And then it is Rob's job, right? That person is going to be the one to round up your assets, pay your bills, and then do what your will says to do with that money, whether it's give it to charity, grandkids, fund a trust for someone. And so it's a big responsibility, and it's yours to choose if you put it in a will. And then a will also only governs assets, though, that are subject to your probate estate. So what do I mean by that? When we talk about beneficiary designations, that's not part of your probate estate anymore. Those items that we go and put either a beneficiary on, life insurance, bank accounts, IRAs, those pass automatically to those beneficiaries. Your will does not control those items anymore, unless for whatever reason those beneficiaries cease to exist and it falls back into your probate estate. And so if we don't manage how we set up those non-probate mechanisms to pass assets with our wishes in the will, or that's not an intentional difference, then basically your will is not going to have the authority or the assets to forward your estate plan in the way that you think it will. So I've said the nasty word, and it's probate, and I find that folks have a lot of opinions on it from either they don't like court, or it's some horror story of one that went on for years and years and years because people couldn't agree. At the end of the day, it's nothing to be scared of. It is simply just a court supervised tool. But it is important to note that if your will relies on a probate proceeding to pass your assets out. So that is that is a public proceeding, and if one of us wishes, right, you can go down to the courthouse and you could type in, if Rob dies, you can type in Rob's name and you can pull up the record and find out what's going on with Rob's probate. So while it's a process and there's nothing to be afraid of, it is something that if you did want to keep something secret, it does not invite the process to be secret.
All right, thanks, Rob. I'm going to dig in a little bit more here on probate and what that involves, because in order to understand the difference between a will and a revocable trust, it's helpful to kind of have a fundamental understanding of what probate actually entails. Probate, at its heart, is the court-supervised administration of a person's estate after they've passed away. In Wisconsin, the law is that if you die and you own more than $50,000 of assets that do not have any sort of beneficiary or payable on death designation, and you don't have any estate plan in place, your intestate that Rob had discussed, or your primary estate planning vehicle is your will, your estate goes through probate. In probate, a person applies to a probate court to be appointed as the personal representative, which is what Wisconsin calls an executor. To apply for such authority, the PR, personal representative, files the will and a set of application documents providing information about the decedent, i.e. you, and their estate. The PR has to give a copy of your will and the application documents to both the beneficiaries under the will, as well as the intestate heirs. And the intestate heirs are those individuals who would receive your estate under Wisconsin statutes if you had no will at all. This is because the intestate heirs are the people who would stand to benefit if your will was found for whatever reason to be invalid. The group of your named beneficiaries and your intestate heirs are referred to as the interested persons in the estate. The court then sets a date that's about 30 days out from your date of application and says anyone with an objection to the application has to make that objection known to the court by that date, or else the estate is going to be opened and the PR is going to be appointed with authority to act. If the interested persons agree with the application, they can consent and the court will act a lot quicker than that 30-day deadline. But if an objection is raised, the application is set for a hearing in front of a judge, which can sometimes be several months out, depending on the judge's calendar. Once the probate estate is opened, the court issues domiciliary letters to the PR. These letters are kind of it's a one-page court order that authorizes the PR to effectively step into your shoes. They can access your accounts and assets and can pay expenses and debts and any creditors that present. The PR is tasked with collecting all of your assets, paying off your creditors and debts, and then making distribution in accordance with the will, if there is a will, or in accordance with the statute that Rob referenced, if you did not have any sort of will. Part of this probate process involves filing an inventory with the probate court. The inventory is kind of a snapshot of it's, okay, here's everything Tom owned and its value as of his date of death. And the court itself charges a fee on that inventory value. Current law has that fee set at a 0.2% inventory filing fee. So effectively, an estate of $1 million would pay the court a $2,000 inventory filing fee. While the inventory is kind of the snapshot of the value of the assets, the PR also has to file an accounting for the estate, and that'll show everything that came into or went out of the estate while it was being administered. And finally, once all of that is done, everything's wrapped up, the PR makes distribution of the remaining assets gets receipts from all of the beneficiaries, files necessary tax returns, and then closes out the probate with some closing documents. The time for a probate proceeding can kind of vary pretty greatly depending on the assets that are involved, any creditor and or beneficiary issues that might present, timing of your death for the tax filing purposes, and the status of any unresolved transactions that were outstanding as of your death. That said, we typically advise that individuals should expect even the most straightforward probate administration to take somewhere between 6 to 9 months from beginning to end. I mean, we've also, as Rob kind of highlighted, that we've had probates that need to be kept open for years in order to deal with litigation or maybe some tax planning that has occurred. As far as the costs for a probate proceeding, it can vary greatly sometimes, depending on the amount of time that's necessary to resolve issues. While it's not required that a PR hire an attorney, most do, just because it is a court proceeding. And an attorney will help them kind of navigate the required filings and deadlines and manage the probate administration. Typically, I mean, we advise that, once again, even the most simple probate administrations will probably run between $3,000 to $4,000 in attorney's fees. And it can easily go up from there if there are beneficiary issues, someone's contesting something, if there are creditor concerns. That's all on top of the fees that the court collects on that inventory filing fee that I previously mentioned. So probate is by no means inexpensive. If you own property in multiple states, there can also be a need to have multiple probate proceedings. Wisconsin probate administration can only govern assets that are located in Wisconsin with like financial. So if you had a cabin in Minnesota, you might need also a secondary ancillary probate administration in that state. So the 10,000-foot picture there of what probate is, the decision for you to make is whether you want your estate to go through probate. As we've kind of hopefully described, probate's not the most efficient method of administering an estate. Before anyone has any sort of authority to access your assets, to pay creditors and expenses, they have to apply to the court and get that court order that authorizes them to act on your estate. While this can happen relatively quickly sometimes if everyone agrees, if anyone doesn't agree or just refuses to sign a consent to the initial application, it might be weeks or months before anyone has authority to act over your estate. In the meantime, there's probably a funeral home that's looking to get paid, or perhaps mortgage or other debt payments that are being missed. And the bank might even be considering foreclosure in order to protect their own interests. Finally, since probate is a court proceeding, as Rob highlighted, the filings that your PR makes are a matter of public record. This includes that packet of initial application documents, your will, and even the estate inventory that gets filed. Therefore, any nosy neighbor could go down to the courthouse and say, I want to see a copy of Tom's inventory. Holy cow, he had X amount of dollars, but now that I think about it, he did owe me $10,000 that I loaned to him. I'm going to file a claim against this estate. Or perhaps maybe your will might, for very good reasons, treat some of your beneficiaries a little bit differently than the others, whether that might be due to disability planning, perhaps there are drug and alcohol problems, or other circumstances. That information being made available to the public can have unintended consequences for your loved ones. To the extent such nosy neighbors and things like that are actually out there, I can't really speak to, but the privacy offered by a non-probate estate administration is often quite appealing. If you do decide to avoid probate, one of the most common ways to do so is to create what's called a revocable living trust. With a properly coordinated revocable trust, there's not going to be any assets that go through probate because they will either already be in your trust or pass to your trust upon your death. With a revocable trust, you're creating an entity that's kind of separate from you personally. I kind of like to compare this to creating a business. You're creating this separate legal entity that is able to hold assets itself and is governed by the terms of its operating agreement, i.e. the trust document. While you're living and have capacity, you are the trustee and the beneficiary. So there's no middleman that you have to go to in order to request a distribution from the trust. For most intents and purposes, assets in your revocable trust are still your own assets. There's nobody that decides whether you can or cannot have access to the trust's assets because you're the one that's making that call. You're the trustee. The document is revocable and amendable by you, and that ensures that it does not have to file any sort of separate tax filing. Any income earned by the trust is picked up by you on your individual tax return. With a revocable trust, nothing is being filed with the court, so there's nothing available for public inspection. Also in a trust, you'll name a successor trustee to take over for you once you're either incapacitated upon your death, or you just decide you don't want to deal with it anymore. You want your successor trustee to take over. Your successor trustee does not need to wait for any sort of special court order to act on behalf of your trust. They're authorized by the trust document itself, and they can act immediately. While some trustees do seek the assistance of an attorney to ensure that they're complying with their fiduciary duties they owe as trustee, since there are not court appearances, some trustees skip hiring an attorney or only hire an attorney to provide them with assistance at certain administrative intervals. Generally, in a living trust, the grantor, the trustee, and the beneficiary are all the same person, you, the person who's creating the trust. When we say a grantor, we're referring to the person or persons who created and funded the trust. The trustee is the individual that holds and manages the trust assets, and the beneficiary is the individual for whom the trustee is holding and managing the trust property for their benefit. Besides identifying the grantor, trustee, and beneficiary, the trust also provides guidelines on how the trust should be managed and administered. These guidelines include direction on how the trustee should make distributions to the beneficiary, what happens if a beneficiary becomes disabled or special circumstances arise, and what might happen to the trust assets upon the death of the primary beneficiary. So hopefully that kind of outlines many of the advantages of creating a living trust, but just to reiterate some of the main points, a properly coordinated trust-based plan avoids probate, since any assets that are titled in the name of the trust don't go through probate, because although the assets in the trust are held for the grantor's benefit, the legal title is in the name of the trustee. When the grantor dies or is no longer able to act as trustee, the named successor trustee has the legal authority to hold, administer, and distribute the trust assets. If the grantor holds real estate or other property in different states, probate can not only be avoided in Wisconsin, but also wherever the other property is located. As we kind of previously highlighted, probate isn't something that necessarily needs to be feared, but it can be a time-consuming and burdensome process after you've just lost a loved one. The legwork in transferring assets is typically, in a revocable trust, the legwork for transferring assets is performed when the trust is established. The successor trustee then continues to administer the trust assets upon the grantor's death without requiring any sort of special court permission or authority or an order from the court. This can provide for a seamless transition whereby the successor trustee immediately steps in and continues the management of the trust. A revocable trust also allows the grantor to provide for the continued administration of the trust, and assets can be continued to be held for the benefit of maybe minor children, grandchildren, or other beneficiaries after the grantor's death and on the grantor's terms via kind of a subsequent trust that would get funded from your revocable trust. And finally, because a revocable trust is not subject to probate, the trust does not become any sort of public document available for inspection. What this means is that for families where maybe privacy is a priority, or there are concerns about family infighting, the trustee is generally not required to give notice to the heirs at law, your intestate heirs, or other potential claimants. This does not mean that a trust is not subject to attach for creditor purposes, but what it means is that the trustee can have some control over who has access and can find out the information about your estate plan. That's all not to say that the trust is without its downsides. The most prominent disadvantage of a revocable trust is that since it's a more intricate and more involved plan, the document is necessarily longer and it takes more time to draft for an attorney. As a result, the revocable trust-based plan is typically more expensive for you to establish versus a will-based plan. However, trusts do often save money in the long run when it comes time to put that plan into action. Unfortunately, typically those are cost savings that you yourself don't see because it happens after you've passed away. The trust costs more on the front end, but it probably saves more in the long run than a will-based plan does. As kind of an example, you can kind of maybe picture two spouses. They own their home. They have maybe 100,000 in their savings account. They have 401k plans and some life insurance, and they want to leave everything in equal shares to their children, who they say get along. It's not always the case. Then maybe a trust might not be necessary. They can still avoid probate by having beneficiary designations in place and maybe a transfer on death designation for their home that gets it to the children without having to go through probate. Where kind of transfer on death or beneficiary designations sometimes fail is kind of planning for the unexpected. I kind of like to describe our job as estate planning attorneys as throwing a lot of what ifs at you. A comprehensive trust document is going to have a lot of what if planning in it. What if a beneficiary predeceases you? What if a beneficiary is receiving Medicaid due to a disability and receiving an inheritance would disqualify them from their benefits? Those are all kind of things that can be planned around within a comprehensive trust document that can't necessarily be planned within a beneficiary designation itself. So, you know, if they have all of that coordinated, that would all pass without probate, all of the couple's assets would be distributable, and a basic will in that scenario may be sufficient to serve as kind of a catch-all. Another potential disadvantage is inconvenience of creating a living trust. Earlier, we kind of described how probate can be an inconvenience while your loved ones are grieving the loss of you. When a trust is created, that inconvenience of that kind of funding moves to the front end in that it happens when you create the trust. It's not like a will where you can just, you go through a signing, you prepare the documents, you sign it, and maybe you stick it in a safe deposit box or another safe location and trust that that will is going to cover what it needs to cover when you pass away. With a trust, that inconvenience moves to the front end, and that you have a lot more homework. You have to not only sign and create the trust, you have to coordinate your assets with that trust that you've created. In that case, you need to retitle everything you own into the name of the trust, or you work with the beneficiary designations to ensure that all of your assets are coordinated with your trust. This can include kind of going to all of your custodians and making sure that the assets are coordinated with your trust. And it's a trade-off between doing the legwork now or having your personal representative do it later. There's also sometimes some utility to having a court oversee the administration of your trust. The court is going to set deadlines throughout administration in a probate administration to ensure that your PR stays on task. There's no one kind of overlooking your trustee in the trust administration. Because the trust is not subject to the jurisdiction of probate court, at least without someone bringing a challenge or some sort to the probate court, the trust assets might not be protected by the creditor claims the way they are in a probate estate. Additionally, unlike the personal representative, a trustee is not subject to the oversight of the court. So not all assets are appropriate to be held in trust. Maybe you could have an ownership interest in a corporation or LLC in a trust, but there could be adverse tax consequences. For example, maybe if the business you own is structured as an S corporation, there are very particular things that need to be in your trust to ensure that it will continue to qualify for that S corporation status within the context of your trust. And finally, an unfunded revocable trust won't avoid probate. If you don't move the assets or coordinate your assets with your trust during your life, you still have a will, and it's a pour over will that basically catches anything that you didn't coordinate with your trust and pours it into the trust. The point being that if you don't use it the way it was intended, you're not going to get the benefit from it. So there's a lot of things that a trust will do. There are some things that a trust won't do. A trust is not the only way to save on estate taxes. There's no greater savings on potential estate taxes if you choose to use a will or a revocable living trust. Same kind of goes with income taxes. The revocability of the trust means that the trust assets can be retitled into the name of the grantor at any time, since you can effectively revoke the trust, and therefore it's still, for income tax purposes, treated as though it belongs to you. While this means that you don't have to, if you have a revocable trust, you don't have to do a separate income tax filing, but any income earned by the trust is picked up on your individual returns. Routine estate planning, such as the use of the portability election, allows the surviving spouse to apply a deceased spouse's unused federal gift and estate tax exemption toward your own transfers during life or at death. So regardless of whether you use a revocable living trust, you're still able to take advantage of some of the estate tax planning provisions. Wisconsin also doesn't recognize a self-settled creditor protection trust. So having a revocable trust doesn't mean that any creditors of yours can't get after those trust assets if you're found to be liable for creditor issues. Those assets in your revocable trust will still generally be attached by creditors the same as if you owned those assets yourself. And finally, the trust assets are countable towards any sort of public assistance programs such as Medicaid or supplemental Social Security income. So just because assets are in a revocable trust doesn't mean you can just transfer everything to a trust and then turn around and go on Medicaid impoverishment. That's kind of the 20-minute highlights there of some of the differences between wills and trusts. The decision on which vehicle is best for you is a very personal one that can depend on many factors. So maybe, Rob, do you want to kind of bring it home on some of the considerations that should go into making that decision?
Yeah, so we've thrown a lot at you guys. And so what I often like to think through with folks is when you're trying to pick between um, a trust or a will-based estate plan is what are your assets and how do they have to be managed? If things are really straightforward, maybe we're cool, we're fine using a will-based estate plan and relying on a power of attorney. But if you have some very sophisticated assets, maybe we want a trust where we have a corporate fiduciary as your trustee to manage those for you because, managing a bunch of business interests is just different than managing Rob's basic checking account. Um, if you have real estate holdings, and particularly in multiple states, and what I often say is, well, there are generally a lot of non-probate workarounds to deal with certain estates. I often call them band-aids because they're things that are very easy to come apart if you start making changes to them over time. And so, particularly if you have multiple real estate holdings, and especially in multiple states, that really kind of lends itself more towards a revocable trust. If you have unique family considerations, right? So this kind of goes back to that privacy thing. But if perhaps we want to write Rob out because there's very legitimate reasons for that, Rob's going to get notice of all of that action under a will-based estate plan. Whereas in your trust, right, Rob's going to be none the wiser. I mean, he might be a little surprised, but he is not legally entitled to that information. The other thing with unique family considerations also is you can, in your will, you can have a trust come into being, right? I have a grandson who maybe has some disabilities, right? And he's receiving benefits. So I want his portion to be held into a trust. Well, it's really inefficient to go to probate to create a trust. You're going to pay for that thing twice, is what I'm telling you. So sometimes if we're trying to manage some of these unique family situations where things aren't maybe just going straight out to folks, kind of lends a discussion of is a trust more efficient for your family than a will. On probate considerations, right? If you've heard what we said and you go, absolutely not, I don't care how efficient, how whatever it is, and you don't want to be there, well, the best way we have to keep you out of there is using a trust. There are follies and risk on any option, but that's the surest bet we can get during this lifetime. Tom kind of talked about, with a trust you pay for and you have the inconvenience of funding it and establishing it now versus making those a tomorrow problem for somebody else. And so what is your appetite for dealing with some of those things now? And then finances, it's got to make sense for you financially, right? If I wouldn't tell somebody to spend all of their money on a trust just for the sake of having a trust. It may just be that, there's other efficient ways to get your assets out without paying for the cost of a trust. And family dynamics, it always kind of comes back to what I talk about with folks all the time is what are the dynamics between you and your kids, and your kids and one another? Because this is gonna, with the emotion of a passing, all that stuff comes to a head, and what environment do we want to create for those conversations to happen? So those are just some things to consider. There's no right or wrong or one size fits all, but I find it's often about more than just the money. And when you figure this stuff out, those family dynamics are really the most important to me. So with that, I think we're going to transition to a question and answer time.
Well, thank you guys. My name is Lucas Kolash, and I'm a financial advisor here at Wealth Distribution Strategies. We've had a couple questions come in prior to the meeting tonight, and I want to go over those first. A question from Warren is, my family trust is over 10 years old, but my children are now adults and they're on their own. Should we update it?
Yeah, I mean, we typically advise clients to kind of go through their estate plan and read through them on their own, at least every 3 to 5 years or so. Make sure that any, special circumstances that you've that apply to you are still applicable, that the people that you've named are still surviving and still be the people that you want to act in those positions. So I mean, it's not just a set thing that, okay, it's 10 years old, it needs an update. There's been some law updates, but nothing that really would substantially affect the operation or administration of a trust just because it's 10 years old.
A question from Kathleen. Having both in a trust and a will sounds redundant. Why have a will if you already have a trust? So I think this was addressed, but I just want to be respectful of the question.
Yeah. I can take that since it was in my section here. So the trust only works in that you've coordinated your assets properly with this entity that you've created, the trust that you've created. There might be maybe some bank account out there that you've missed either retitling or putting a beneficiary designation on that account. And so therefore it's going to be an account that you own personally, and it doesn't have any sort of payable on death designation on it. And therefore it has to go through probate, and anything that has to go through probate passes by your will. But with a revocable trust-based plan, we're going to provide that will. It's going to be a pour-over will. So it's going to catch that asset and it's going to pour it into the trust so that everything flows still with your primary estate planning vehicle.
Thank you. This is a question from Patrick. What are some of the options for providing family members with the most benefits and the lowest taxes from your will or your trust?
Rob,
I mean,
okay.
it's I'm trying to think of the most benefits. I guess I will answer it this way. If within the dynamics of your family, there are reasons that things just shouldn't just shoot straight out to the next generation, but perhaps we want to have some contingencies on it for a substance abuse problem, a disability. We're just worried about kids spending through money, right? That's the very legitimate thing that I talk about all the time. To preserving the assets over the long run and potentially putting some parameter around that, that's really where the trust is going to, probably lend you more favors than a will. As far as taxes, a lot of that, right? You're right. Tom talked about the portability earlier with tax, right? So we each get, right, like $13 million during our lifetimes and at death to give away, right? So if I'm married, we're talking like 26. So either of these options, that number is still what that number is before we have estate taxes. So that part's kind of moot. But if we have ongoing payments coming out of an ongoing trust, we certainly don't want those to be taxed to the trust. Meaning we want, right, a K-1 if you're like a business owner. We want Rob as the beneficiary reporting the income that Rob receives from a trust on it. I'm not sure if I'm answering the question, but between these two, they're pretty similar outcomes.
Thank you. Could you cover the look-through language needed to get 401k assets transferred to the trust as a beneficiary versus the direct heirs?
Yeah. So when we're dealing with retirement assets, the rules on all of that kind of got upended a couple of years ago with the passing of the Secure Act. What it says now is that if you name a non-spouse beneficiary as the beneficiary of any tax-deferred retirement type accounts, that beneficiary has to deplete and pay the taxes on that account within 10 years. But if you name a non-individual, like a trust, it's typically a 5-year payout period. There are special language provisions that you can have in your trust document that will allow your trust to qualify for that 10-year payout instead of being subject to the 5-year payout. There are kind of of different options for that, and that could be the subject of a whole hour-long presentation follow-up on it. But the gist of it is the simplest way to do it is to say that, okay, any distributions from the retirement account to the trust have to immediately be paid out to the beneficiary of the trust. Sometimes that's not the best result, depending on circumstances, for why the trust exists in the first place. So there are options to qualify a trust for a 10-year payout.
Thank you. I'm going to keep going through some questions that are in the chat, everybody. If we don't get to them, we'll keep them in mind, and then we can reach out to Boardman and Clark too and follow for you. So this question is from Richard. A number of my neighbors have put their primary residences in a trust. What are the advantages and disadvantages using that approach?
Yeah, so I mean, if you decide to have a revocable trust-based plan, the options for your house are to either retitle it in the name of the trust that you've created, or put what's called a transfer on death deed, record that with the county so that upon your death, it automatically goes into the trust that you've created. And then your real estate gets all of those advantages and disadvantages of a revocable trust that we discussed in the presentation.
Can a trustee be joint, i.e. a husband and a wife?
Yes, and that's very common for if a married couple is creating a revocable trust. Typically, they're the primary trustees, and as long as one of them retains capacity and is living, then there is no need for a different successor trustee.
Thank you. This question is from Susan regarding irrevocable trust and the estimated cost to set up a trust. And is there a cost to close the trust for the heirs?
Difficult question. There's it depends. It's the lawyer's favorite answer is it depends. Why are you creating the irrevocable trust? A lot of times if you're creating irrevocable trust, it's maybe for the purposes of planning to apply for Medicaid. So that, when people talk about, oh, the nursing home's going to come after all of my assets, there's an option. It's not a great option, but there's an option where you can set up an irrevocable trust during your life, transfer assets to that irrevocable trust, and therefore they wouldn't, and wait out a 5-year period, and they wouldn't count as your assets for Medicaid purposes. Those aren't great because you lose a lot of control over those assets. You can only retain an income interest from that. And so is there a cost? I mean, there's costs for everything. I mean, your trustees probably getting compensation. If they've hired an attorney, they're paying attorney's fees from that trust. But it's not necessarily there's no state entity that's saying, okay, you're terminating the trust, now you owe us $10,000 or anything like that.
Thank you. Do trust asset bases adjust at the primary guarantee's death?
Revocable trust assets do, yes. They get a basis step up so there's still, since it's a revocable trust, it's still included in your estate for estate tax purposes, and therefore it gets a basis step up upon your death. Irrevocable trusts do not.
Thank you. What circumstances would benefit by an irrevocable life insurance trust?
Yeah, so an ILIT is what attorneys love their acronyms here. With an ILIT, generally the idea is that you're owning life insurance. That's the idea behind that is to make it available to pay for any estate taxes that are owed upon your passing, and therefore the proceeds of the life insurance benefit are not included in your estate with a properly coordinated islet.
Thank you. Couple more questions here. We have a disabled nephew receiving Social Security. How do the assets allocated for him pass without jeopardizing his eligibility, and who monitors that? If you
Go
want
ahead,
to
Rob,
pause
take a
first.
couple.
Yeah. Well, so it depends where we're going, right? So if we're planning for that stuff ahead of time, you know, we can, if we, right, we don't want him or her getting that asset and then jeopardizing their benefit. So in either case, we're probably going to talk about trying to put those assets into an ongoing trust for that person's benefit. So you can do it two ways, right? You can either have a probate proceeding to create a trust, or that portion of, or if you have a revocable trust, that portion that would go to that beneficiary can either, right, and you might give multiple off ramps here, but right, you might draft the trust in a way that, you know, the trust for Rob would otherwise qualify as a special needs trust. Or you might just say to your, you know, give your trustee the power of, hey, if there's a beneficiary that is receiving these beneficiaries in Wisconsin, a lot of those special needs trusts are WISPAC, you know, can go and make that account with that entity to keep those assets from vesting in the beneficiary's name and jeopardizing the benefit. So we can do it any number of ways, but it's right. It's thinking about that stuff ahead of time is the key to it.
Could you distinguish that process versus an ABLE account?
So, and I'm not as well versed on this, so I'll defer to Tom. I
Sure.
know ABLE accounts have more to do with Rob while he's alive and working.
Yeah. So, and we have attorneys on staff here at Boardman and Clark that are a lot more well versed in kind of special needs planning. But so to qualify for certain benefits, you can't have over $2,000 of your own assets. However, to the extent that assets are in a supplemental needs trust or in an ABLE account, those funds don't count towards that $2,000 limitation. Wisconsin itself doesn't have an ABLE account system, but you can create an out of state. You can create a Michigan ABLE account, fund it, and then the beneficiary of that account has a lot more freedom and a lot more say over what happens to those assets. But it's structured in such a way that it doesn't count towards that $2,000 limitation.
Thanks, Tom. Is the administrator of a trust typically an attorney?
When we say administrator, I assume we're referring to trustee, the trustee, and the answer to that is no. We don't want to be trustee. We try to avoid it. There are banks and companies and individuals that do that professionally. Now we'll be there to advise that trustee of what they need to do to administer the trust, but attorneys typically do not want to act in that authority.
You. There's a question here about irrevocable trust from Richard, but I believe this has been covered since. What is the minimum basic legal requirement in Wisconsin for a will, and how is the document recognized as official?
So, right, it's a writing signed by the testator and two witnesses. So the testator is the person making the will, right? So it's not a piece of paper that Rob signs. You've got to have some disinterested witnesses to the will, right? So it's a writing signed and dated by the testator and two disinterested witnesses. Is the minimum, assuming whatever you wrote makes sense, is also the other part of it.
And it's not official until it's admitted to probate upon your passing, which means that the intestate heirs have had their opportunity to object, and either those objections have been resolved or they have consented or haven't made an objection.
Thank you. This looks like the last question. can one of your beneficiaries in a trust be a special needs trust that you have set up for a disabled child?
Absolutely. Yes. In fact, if you have a disabled child that's receiving benefits, that would be our first recommendation for your trust, is to fund a special needs trust for that beneficiary. Whereas, going back to that kind of $2,000 limitation, if the disabled child has their own assets that they're going to receive from your inheritance, that could disqualify them from their benefits. But if you instead fund that into a special needs trust for their benefit, then those assets don't count as theirs for that purpose.
Well, thank you, gentlemen. For everybody else, if you do have any more questions, feel free to contact us at WDS, whether it's your advisor or just another member on our staff. I want to thank Tom and Rob and the Boardman and Clark organization just for being a part of the meeting tonight. Our next event will be a month-long basketball contest in March, like a March Madness contest. So we're going to send the clients, we'll send you all an email so you can get the details and open up that registration link soon. We also welcome the feedback from everyone about our events, so please reach out to your advisor or email us at info@wdstrategies.com to let us know how we're doing or other topics that you'd like to see us present about. And again, I want to thank everyone for joining, and we hope to see you soon, and have a good night.